Lord, my other war that I wage, and which I think the Judicial Council will have a role to play, is in respect of the legal reforms that we want in legal education. Some faculties have been accredited to run the academic programs, but they have not been accredited to run professional programs. But there's been a bloat in the number of the faculties that produce men that obtain academic qualification necessary for you to train as a professional lawyer. So our monolistic law school is inundated with the numbers. And I've seen hesitation on the part of the Judicial Council, which has very large membership on the General Legal Council, to advise that the law school, there should be, by way of license, so to speak, the faculties be granted the license to also train professionally, and then we can have one bar exams, whether twice a year or once in a year. The modalities can be agreed upon. But we need the faculties to train professionally as well as our law school, as it is. When you get onto the Supreme Bench, will you consider by way of policy? Because every Supreme Court judge has the potential of acting as a Chief Justice at one time. Will you, as by way of policy, give this firm support that the law school, the faculties be permitted to train their products professionally, so one exams or test can be set for all of them?
Thank you, Mr. Chairman. I know Honorable Member is a very strong advocate for this. We have to weigh two things: quality as against quantity. I think there is, or there must be, some reason for which the law school at Makola is built near the court. Because I keep saying the court is the lab where you go to do your practicals. Yes, I agree with you that other professional courses, professions like accountants and others train elsewhere, whatever you want to train, and write one exam. I know that's what you are advocating for, that the faculties should be allowed. But the question is whether we can have control over the way they are trained. We don't just necessarily say because you pass the exam, fine, you are qualified to them. There must be some training session, some training procedures. It's a dicey issue whether all faculties should be allowed to train their lawyers and then they write one exam and they all qualify. If we have the facilities to regulate and make sure that they go by the...
But by way of assistance, would you be of a different opinion if the curricula is redesigned to capture the essence, the matters that...
Exactly what I'm saying. If that is done, and the faculties must be supervised to make sure that they attain that level of standard we need, fine, why not? Then they write one exam, and then when you pass, you become a lawyer. So I'm for it. But then we must watch the quality. Thank you.
My Lord Dzamefe JA, as is GSC soon to be.
Thank you.
I thank you for your answers. Let me also add that in your previous answers, I've listened to your concerns regarding the proposal to have time limitations for trials. The Rules of Court Committee hasn't done well in this matter. So let me inform you that by way of private members bill, something is coming up like that. To be called the Fair Trial Act. Yes. Now, my Lord, let me say this. I've seen that you've been on the bench from...
Honourable members, the fact that the Rules Committee have not done well should be expunged from our records.
Chairman, thank you very much. You've been on the bench since 1988, actually, for the records. So that's about 37 years as a judge.
Yes, Mr. Chairman.
And yet we are now considering for the Supreme Court. Congratulations.
Thank you.
I wish you all the best on the Supreme Bench.
Thank you, sir.
Thank you very much.
Thank you, Honourable Roxanne Nelson, Eche Kwame Dapamopo. It's now the turn of Honourable Minority Leader and the ranking member of the committee.
Chairman, thank you for the opportunity. Chairman, as you read in your opening statement, this committee is fortified by a letter from the President dated the 20th of May, 2025, which letter states as follows: that on 29th of April 2025, I submitted my nominations by letter to the Judicial Council for appointment to the Supreme Court. The chairperson, Acting Chief Justice Bafo Boni, on behalf of the Council, advised me on the 5th of May 2025 of the suitability of my underlisted nominees for appointment to the Supreme Court. The letter goes on. In accordance with my duty under Article 1442 of the Constitution of Ghana, 1992, I consulted with the Council of State by submitting the above names and their curricula vitae to the Council of State. Next sentence. On 7th May 2025, the Council of State notified me by a letter and a report indicating their suitability for appointment. Honorable nominee, from the President's letter, it is obvious to me that Council of State did its work within 36 hours or less. May I know from you whether you were contacted by the Council of State as part of their work before recommending you? May I know from you?
Mr. Chairman, I was not called by the Council of State to meet them, no.
Now, would you disagree with the suggestion regarding the speed with which the Council of State communicated back to the presidency? 36 hours, Council of State consultation. Do you find it rich?
Mr. Chairman, that one is beyond my
Very well.
control.
Very well. Now, as part of our own due diligence as a committee, we peruse your CV. And here, just to avoid surprises, I want to ask you whether you have your CV with you. You have it right with you?
Yes, Mr. Chairman.
In soft or hard copy?
Hard copy.
Very well. So we'll have a little exercise on your own CV.
Okay.
Good. So as part of the due diligence that this committee did, it attempted to validate some of the information by relying on other institutions of state. On the issue of educational background, item 1, Norwegian School of Management, Oslo, Norway, MBA in Leadership and Strategic Management. The state institution relied on to validate this could not confirm this for us. Are you able to provide us with the certificates and the transcript of this qualification you've so provided yourself?
Yes, I'll do that. I
Very
can.
well.
Then the state agency you relied on didn't do a good job.
Yes, we relied on the NIB. They wrote to us formally.
I schooled there, and I can provide you the necessary things you want.
The NIB wrote to us formally. Now, let us, so you agree that sometimes our state agencies make mistakes or they fail us. You agree with me on the basis of this, since you said they didn't do a good job. Obviously, that's the result. Anyway, let's make progress. This program, you've stated that you did it between 1994 and 1995. Was it a scholarship from the Judicial Service, full-time program you took off your work as a judge and pursued in Norway, or it was some correspondence or part-time?
Mr. Chairman, this is a full-time course. I was given scholarship by the Norwegian government. In 94, 95, when we were integrated into the mainstream judicial service, we were not working. So I took the opportunity, took permission from the service, and went to pursue this course and came back after a year.
So the scholarship was not routed through the judicial service?
No, it was the Norwegian government scholarship.
Did you apply for it?
Yes, I did.
Very well. Now, you've answered the question regarding the number of judges at the Supreme Court. Are you sure they are 13 and not 14? I'll give you the time to reconcile that. We'll come back.
What if yes, okay, if you give him the time, I can refer to our diary and see the correct numbers.
Yeah, sure. That's what I'm saying. I'll give you time to reconcile that. Now, still on your CV, you went to the training college.
Yes, Mr.
After
Chairman.
the O-level.
Yes, Mr. Chairman.
Then just after the training college, you went to the university from the records and the dates you provided.
Yes, Mr. Chairman.
So,
I taught for a year before going to the university. Yes, before going to the university. After I finished training college, I taught for a year. Within that year, I went to the university.
So you taught for a year, but you've not indicated the school you taught. You've not indicated that on the CV.
But that was in Pando in 1978.
Very well. Because, so when did you finish the training college? Which you say 75 to 78. The academic calendar, do you readily remember which month of the year you finished, you completed your program at Jessica?
I think we finished in June, July 78, and I was posted to Pando Gabi LA Middle School. I taught in that school until November, December, when I went to the university.
Okay.
So you can check from the Ghana Education Service.
No, my lord. If you say I can check from Ghana Education, that's fine. No, I'm
not you personally.
Yes,
I mean, we can cross-check.
No, I'm dealing with your CV. I'm dealing with your CV. So that's why I said, do you have it with you? A little bit of patience would help. Okay, so it's your own record. It is not anything hypothetical. So now, according to you, 78, you were done with training college around July. You were posted, and then you taught up to December, correct? So that ends 78. Then you have here LLB, University of Ghana, Accra, Ghana, LLB, Hans. Then you say 79 to 82. So I want to know from you, the 79, which month, if you recall, did you start your first academic semester?
Mr. Chairman, I finished training college in 78, was posted to Pando Gabriele Middle School. I was a teacher there and entered the university the following year, 79. We started, I think, in September 79. I didn't enter the university in 78. I entered in 79, sir.
My lord, I didn't say that you entered the university in 78. I haven't said that. You said you taught up to December. The records would bear me out. That's why I repeated it just for clarity. No. So you relax, be with me here. Be with me here. There's nothing to worry. It's your CV we are perusing. So when you were done with training college in July of 78, your earlier answer was that you were posted to a school in Pando and you taught in that school up to December of 78 and entered university, please, entered university in 79. Please clarify.
Thank you, Mr. Chairman. I taught for a year in Pando, that's 70, and entered the university in 79. I went to Jaskan Training College in 1975. We were the first batch of a 3-year post-sex. Finished in 78, and I was posted to Pando Gabi LA Middle School, where I taught for 1 academic year. And in 79 September, I went to the university. So if Mr. Chairman, the CV says 79 to 82 to the university.
Yeah, so it means that your earlier answer that you taught up to December.
I don't remember. Did I say that?
Yes.
Oh, then I'm sorry.
That's why I came back.
Then I'm sorry.
Yes, that's why I came back
No.
for you to reconcile.
No.
Okay, very well. So, my lord, you also said, you stated on your CV, you said you went to training college after your O-level. Now, I am aware of Cape Coast University those days. They would admit A-level, SS, professional, or mature students. Did you enter the university with your O-level certificate, or you entered as a mature student, or with a combination of your post-secondary certificate, that's your training college certificate?
Mr. Chairman, I entered with 3 A-levels, not post-sec degree certificate. I wrote the A-levels whilst in the training college. We have adult education courses there, and I had 3 papers before entering the university. I wrote the A-levels in the training college, and that's what I used to enter the university.
Which subject did you do for your A-level?
Economics, religion, and geography, and then general paper.
My lord, you said you only speak English and Ewe, correct?
Fluently, correct.
But you stayed in Aguna Sudro for more than 6 years, and Milord did not make an attempt. Is that the case?
At least I can speak some little, like yours, Abazi. I can say that one.
My Lord, but Aguna, they speak Aguna. Aguna Sudro, they speak Aguna.
Well, I wrote English and Ewe because those ones I can speak fluently.
So, but the tree, we are there on Kakanga.
I understand you, but let's keep it there.
Very well. My Lord, let's do a little exercise on Article 126. Let's go there. Please, you have your constitution with you. My Lord, you there? Yes. Very well. In your earlier submissions, you indicated that Superior Court justices retire on their salaries, correct?
Not yes, but not fully, because you need to do a number of years.
Okay, so if you say you need to do a number of years, let's bring clarity to it. Superior Court justices are in 3 categories: Supreme Court, Court of Appeal, and the High Court. Correct?
Yes, Mr. Chairman.
Now, which of these categories? 4, Regional Tribunal stroke High Court, Regional Tribunal Chairman stroke High Court. Very well, it's the same thing, 3. I don't want to talk about Regional Tribunal. I'm not interested in the populist revolution thing. I'm not interested in that. I won't go there. I won't mention Regional Tribunal. I will not. You can do your own thing. I'm not interested in tribunal where you use your aura, abuse people's rights. I'm not interested. I'm dealing with
Honourable members, order.
Chairman,
the reference is to Article 126.
Very well, let's
the
proceed.
judiciary shall consist of the Superior Court of
Chairman, I'm able to read.
comprising the Supreme Court, the Court of Appeal, the High Court, and Regional Tribunal. So you cannot say you are not interested in the Regional Tribunal when you are making reference to Article 126.
Chairman, thus far, we've had some peace. Restrain your chief whip. We kept quiet for him to ask all his questions anyway. So, which of the categories is the number of years of service applicable to?
Mr. Chairman, some people join the service from after civil servants who have retired. For example, there were 60 where they were working before joining us.
My Lord, I'm not stopping you. I'm not stopping you. Please. We may stay longer depending on your approach. We may have a very short session if we deal directly with the issue. And that's what I would prefer, the latter approach. So, please bear with me. We know the Constitution defines 3 categories: Supreme Court, Court of Appeal, High Court / Regional Tribunal chairs. And in your answer, you qualified the earlier position you had taken, that Superior Court justices retire on their salaries. You qualified it by saying that, yes, but it depends on the number of years of service. I want to know from you, of the 3, High Court, Supreme Court, Court of Appeal, which of them is this number of years applicable to enable them retire on their salaries?
Mr. Chairman.
Or is applicable to all?
It's applicable to all.
Oh, I see. So, for instance, if a person is nominated to Supreme Court and he serves only 4 years and retires, is it the case that he would not qualify to retire on a salary? Is that the case?
Mr. Chairman, it depends on the number of years you've done the civil and the public service before joining.
So let's be specific. The person,
if you, sorry, okay.
The person came from the bar. He's a private practitioner who was nominated, a professor at a private practitioner from the private sector, a businessman, someone who has worked with corporate Ghana and not in public service or civil service. Please, I'm done.
Mr. Chairman, what I know and what I'm saying is that if you are from the public service and you join the judiciary, if you do 10 years as a judicial officer, you retire on your salary. But if you join from outside and you don't do the 10, if you do 20 years before coming, will be added, and then you qualify. It's a constitutional provision.
Please, okay, they are saying Article 155 from here, if you may read that aloud.
Mr. Chairman, it states that notwithstanding the provision of this chapter, a justice of the Superior Court of Judicature who has attained the age of 60 years or above shall, on retiring, in addition to any gratuity payable to him, be paid a pension equal to the salary payable for the time being to a justice of the Superior Court from which he retired, where A, he has served for 10 continuous years or more as a justice of the Superior Court of Judicature, or he has served for 20 years or more in the public service. For 20 years or more in the public service, at least 5 continuous years of which were as a justice of the Superior Court of Judicature. And upon retirement under the clause, he shall not hold any private office of profit or emolument, whether directly or indirectly.
Honorable nominee, may I know from you whether, in view of the provisions in Article 126, having regard to your earlier position that to enable the court function properly, human resource is critical. That is, judges and officers of staff, judicial service staff must be paid well. Would you recommend a constitutional amendment which will incorporate the lower court justices, i.e. district magistrates, circuit court judges, to come under this provision of retiring on their salaries? Would you recommend that?
Mr. Chairman, this depends on the kitty. I wouldn't recommend that. I think this is an incentive for you to work hard and enter the Superior Court. I think it's a way of rewarding you for your hard work. So I wouldn't recommend that everybody falls into that category, sir.
Now, Superior Court justices come under Article 71 office holders, correct?
Yes, Mr. Chairman.
So, High Court judges, Court of Appeal judges, and Supreme Court judges, every 4 years, enjoy the Article 71 emolument, correct? Every 4 years, correct?
When you say emolument, every 4 years they enjoy the emolument, I don't understand you. Judges, our salaries are not reviewed every year. It's done once in 4 years. So what is paid back is the difference. That is what is paid every 4 years.
Let's go to Article 71. Lord, let's go to Article 71. Yeah, my Lord, if you may read 71 for us.
Okay. All of 71.
Rightly so.
The determination of certain emoluments, 71. The salaries and allowances payable and the facilities and privileges available to A, Speaker and Deputy Speakers and Members of Parliament. B, the Chief Justice and the other Justices of the Superior Court of Judicature. 3, C, the Auditor General, the Chairman of the, and Deputy Commissioner of the EC, the Commissioner for Human Rights and Administrative Justice and his deputies, and the District Assembly's Common Fund Administrator. D, the Chairman, Vice Chairman, and other members of D1, National Council for Higher Education, so I described. 2, the Public Service Commission. 3, National Media Commission. 4, Lands Commission. 5, National Commission for Civic Education. Being expenditure charged on the consolidated fund shall be determined by the President on the recommendations of a committee of not more than 5 persons appointed by the President, acting in accordance with the advice of the Council of State. 2, the salaries and allowances payable and the facilities available to the President, the Vice President, the Chairman, and other members of the Council of State, Ministers of State, Deputy Ministers, being expenditure charged on the consolidated fund, shall be determined by Parliament on the recommendations of the committee referred to in Clause 1 of this article. For the purposes of this article, and except as otherwise provided in this Constitution, salaries includes allowances, facilities, and privileges, and retiring benefits or awards. Thank you.
So, back to your earlier position, you said that every 4 years, when this committee meets and makes recommendation, because your salaries are not done yearly, they make recommendations and you are paid salary arrears, correct?
Yes, Mr. Chairman.
Which is known on the streets as emolument.
Yes, Mr. Chairman.
So, you disagree with any suggestion to the effect that Article 71 is only there to benefit the political class from the reading you have just made? From what you have just read.
Mr. Chairman, what the Constitution says is what it is, not the interpretation people put on it. This is not, it doesn't mention a political class here. It mentioned the categories of people who should enjoy this Article 71 emoluments.
Yes. So I'm saying that from what you have just read, those to benefit from Article 71 is not limited to the elected political class. That's the point I want to make from what you've just read.
Yes, I think you are right.
Correct. Now, my Lord, I want us to go back to an earlier position taken by my respected learned colleague, the leader of the House, Honorable Ayarga. He relied heavily on the CJ, Justice Araba Isaba Tokono's recommendation to suggest to you that there's really nothing wrong in increasing the numbers at the Supreme Court. And you seem to have agreed with him, correct?
But the reasons given by the honorable man, I said yes.
Very well.
Because I haven't seen the article she wrote.
Very well. Yes, of course, he quoted from the, copiously from the letter. Now, you would agree with me that this proposal led to a public outcry. But now, we are adding 7 more to the same court. Would you, as a beneficiary of this, would you say that that criticism was unfounded?
Mr. Chairman, if I got it right, it's the Judicial Council that raised the first criticism. The Judicial Council, if I got it right, that the names didn't originate from them. That is all I know. So it was not like I am a beneficiary of, like the word you use, beneficiary. No. I was nominated by the President of the Republic to become a Supreme Court judge. I don't know whether it's based on an article or anything. I just was nominated, Mr. Chairman. So I cannot tell whether I'm a beneficiary or people, no.
My Lord, the argument was to the effect that the courts, the Supreme Court, the highest court of the land was being packed. And in fact, a colleague of yours who had been vetted, I think my lady, is it Benasco, wasn't it? Yes, I have here. Your colleague, Justice Sophia Rosetta Oduokua Benasco Esa, who had been nominated, vetted, and a report submitted to the plenary. As a result of this rather loud disagreement, Parliament could not even take the report. And the loud disagreement, including threats on the floor that laying of the report will generate chaos, eventually prevented the laying of the report. I want to know from you that in view of the argument that even these two adding to the Supreme Court would amount to packing, would you now disagree with that opinion that this 7 being added, of which you are a beneficiary, worsens the matter?
Well, before allowing the chairman of the committee to answer the question, I would ask that the issue of a threat to the laying of the report be expunged from the question. Please proceed to give an answer.
Chairman, I speak of the record, though I will respect your ruling, but I will pull the Hansard. Fortunately, my respected colleague who used the word, there will be chaos. Hansard captured him. If you are ruling it out now, I don't mind to take that one out, but I will bring the Hansard to just, we are not done yet, so I would bring it, so at least once there's a record.
Honourable members, I believe and support the principle that matters that happen on the floor of Parliament is a closed book. Please proceed to give your answer.
Thank you, Mr. Chairman. I'm not even privy to all that happened in Parliament, whether there was chaos or there were threats. I don't know anything about that. I have just been nominated to the Supreme Court. I don't know anything as to whether I benefited from anything or, I don't know, Mr. Chairman. I can't exactly tell what happened on the floor of Parliament. I don't know. That is what I can say, Mr. Chairman.
My honorable nominee, did you become aware of the general apprehension in the public space regarding the two nominees as same amounting to the packing of the Supreme Court? Did you become aware of the general apprehension in the public domain at the time?
No, Mr. Chairman.
Okay, fine. Would you disagree with any suggestion to the effect that this 7 nominations from the president at a go amount to the packing of the Supreme Court? Would you disagree with that suggestion?
I think you answered this question, said no. So why is the question being repeated? So, Honorable Minority Leader, with all due respect, proceed with another question. He says no to it.
Honorable nominee, the Supreme Court of Ghana has not been capped by any constitutional imperative, correct?
Yes, sir. Yes. There's no cap.
You would therefore agree that circumstances may result in having a certain number on the bench, correct?
Yes, sir.
So, in view of that, you would disagree to any suggestion that seeks to condemn or criticize or create a certain apprehension when nominations are being made with justifications for the number to go up to a certain point. You disagree?
Mr. Chairman, it depends on the justification. It depends on the exigency and the justification accorded to the nominations. Thank you.
You will agree with me that the current 7 nominations have not been accompanied with any verifiable justification or exigencies. You would agree with me?
Mr. Chairman, I'm not appointing authority, so I wouldn't know why. So it's difficult for me to answer why.
Chairman, I want to register a protest on record. I know that you are not sharing your power. I would plead through you to my respected colleague seated immediately to your right. The interjections, though not on record, those interjections are becoming too loud and too many. And we've started well. The man seated there, I've appeared before him, and he knows me very well, and I know him very well. We are discharging a constitutional duty. If it were to be on personal level, I say, my Lord Dzamefe, please, I've passed you. We are doing a constitutional exercise, and we have political views on certain matters. You've had your turn. This thing that we do, then it get out of hand, the public misconstrue us. I don't want it to happen. Please restrain him. Please restrain him. It must not continue.
All other members are accordingly restrained. The floor is given to the minority leader and the ranking member of the committee. So
you must add or sign to be say that.
No, this attempt to run me under the bus, I won't accept it. Were you not interjecting me? Were you not? Did anybody protest? Please.
You have the floor. You have the floor. Please continue with your question.
You can't run me down there. You can't. What am I talking about? Please proceed.
Honorable nominee, may we do some exercise on constitutional evolution and textual fidelity? In your view, when should the Supreme Court adapt constitutional interpretation to changing circumstances, whereas at the same time, a view regarding adhering strictly to original text has to be complied with? And maybe let me hear you on that, then I can do a follow-up.
Mr. Chairman, the Supreme Court, as the apex court, is a policy court which we cannot deny. That is why they are not bound by their own decisions. When they think fit to do so, they can depart from their decisions based on the evolving nature of the law and situations. So the Supreme Court, saying that something has to be done, are at liberty to depart from their previous decisions. That's why they are not bound, Mr. Chairman.
Can you provide an instance where you would favor evolution and one where you would insist on textual fidelity? I know I have a textualist right by me, but who am I to even say he's seated to my left or right? I have
Please
a textualist with me.
proceed to ask your question. Nobody seated by you has the power to interpret the Constitution. Ask your question.
So may you provide an instance where you will favor evolution and an instance where you would insist on textual fidelity?
Mr. Chairman, if the Supreme Court gives a decision, we are all bound by it. But then, when you can depart when the decision is given per incuriam, or a wrong law has been applied, or the decision becomes and just in the circumstances. And if you can differentiate the facts, you can depart from it. Mr. Chairman.
Honorable nominee, let's talk about judicial ethics and independence. Would you be able to give us 3 specific measures you would implement or you suggest to be implemented to maintain judicial ethics whilst preserving independence?
By the ethics of our job as judges, 1, you go strictly by what is before you, that is the evidence before you, and the facts. If I got the question right, you base your decisions on the evidence and the facts before you. You are not to depart from this. And then if it's I don't know whether it's the social aspect you are asking, your comportment, your rapport with lawyers who appear before you, it's there. You must know how you relate to parties who appear before you, the language you use in court, comportment, as I said earlier, your punctuality, even your own outlook as judges. And then you must not meddle into politics. You must be independent. You must just give out your mind. You don't care whether it's coming from A or B. These are some of the ethics we go by. And then you must know where you go and where you don't go, where you are seen and where you are not seen. Thank you.
So in view of that, how would you then balance the question of transparency with the need to avoid inappropriate commentary on legal issues?
You just have to know how to balance it. It's a thin line. If you heard me earlier, I said comments and opinions passed by judges carry a lot of weight because you don't know when a case will come before you. So you have to be very sparing as to comments you pass because, 1, a case may come before you and the facts may be different, not on all fours. You have to depart from what you said. Even some people can even petition your recusal from the case because of a comment you once passed. So you have to be very careful as to the comments you pass as a judge because it carries weight.
Now, you are aware of the ECOWAS courts. You become aware of the ECOWAS courts, my lord.
Yes, Mr. Chairman.
And you've equally become aware of other judge-made laws in other jurisdictions that sometimes lawyers appearing before you may rely on for persuasive purposes, etc.
Yes, Mr. Chairman.
Now, in your view, should foreign constitutional precedents influence Ghana's constitutional interpretation?
Mr. Chairman,
if I may add, just to make it composite, when, if ever, should the Supreme Court cite decisions from, say, South Africa, United States, United Kingdom, or even ECOWAS court decisions? I may take it again if you want to take down the question. Are you okay? Okay, proceed.
Mr. Chairman, any decision from outside is persuasive. It's not binding on us. But then, for sake of best practices, we are not a committee of nation. We belong to a committee of nations. Sorry, we are not an island. You can learn best practices from other areas and import into the law, but that should not override your own laws, because whatever comes from outside is persuasive.